What if I told you that a single memo, buried in a filing cabinet for 26 years, was worth almost $5 billion? On July 9, 1999, a Los Angeles jury ordered General Motors to pay $4.9 billion to six people. Six. Not 6,000. Six. And that verdict did not just break records, it broke the auto industry. But here is what nobody talks about. The number in the headlines. It is not what they actually got. And the real story, the one that changed personal injury law forever, starts on a night that was supposed to be peaceful. Christmas Eve. December 24, 1993, Los Angeles. Patricia Anderson is driving her four children and family friend Joe Tigner home from church. The youngest child is 8 months old. The oldest is 9. They are in a 1979 Chevrolet Malibu, a family car. A car GM sold as safe. At a red light, everything stops. A drunk driver slams into the back of that Malibu at 50 to 70 miles per hour. The impact alone should have been survivable. Rear-end collisions happen every day. But this Malibu did not just crumple, it exploded. The fuel tank, positioned just 11 inches from the rear bumper, ruptured on impact. Gasoline sprayed across the undercarriage. And in seconds, the passenger compartment was an inferno. Patricia and Joe escaped through the front doors, but the four children were trapped in the back, burned alive inside the vehicle. The most gravely injured was 5-year-old Alicia Parker. Her burns were so catastrophic she lost the fingers on one hand. She would endure more than 70 surgeries. 70, and she was 5 years old. Now you are probably thinking, tragic drunk driver story. Happens every holiday season. But what turned this into the largest personal injury verdict in American history was not in the police report. It was in a memo, written 6 years before Alicia was even born. In 1973, GM engineer Edward Ivey sent a memo to management. And this was not a blueprint. This was a math problem. Ivey calculated that moving the fuel tank to a safer location, 20 inches from the rear bumper, where older GM models had it, would cost $8.59 per vehicle. $8.59. But Ivey also calculated that leaving the tank where it was, 11 inches from the bumper, vulnerable, the cost of litigating the deaths and injuries would be just $2.40 per vehicle. $2.40. General Motors knew they could save lives for $8.59 per car, and they chose not to, because doing nothing was cheaper, by $6.19. And one more number from that memo. The value Ivey assigned to a human life, $200,000. That is what GM thought your life was worth in 1973. GM did not just make a bad calculation, they made a choice. And they buried the evidence for 26 years. But here is the open loop, that $4.9 billion verdict. The jury had a very specific reason for that number, and it is going to make you furious. The case went to trial in Los Angeles Superior Court. Judge Ernest G. Williams presiding, lead counsel, Brian Panish, a legend in product liability law. GM's defense was simple. We met federal safety standards. The drunk driver was at fault. End of story. But Panish had that memo. And he had GM's own crash tests, internal tests, never public, showing the fuel tank rupturing in rear-end collisions at 25 miles per hour. 25 miles per hour. The drunk driver hit them at 50 to 70. GM fought to keep the Ivey memo out of evidence. They wanted the jury to see the drunk driver's blood alcohol level, 0.20, more than double the legal limit. But Judge Williams excluded the drunk driver's BSC. He excluded the criminal conviction. He even excluded safety data showing the Malibu had low death rates in other crashes. Why? Because this trial was not about who caused the collision. It was about whether GM sold a car they knew was dangerous. One question. Did General Motors act with fraud or malice? 10 weeks of testimony, engineering experts, burn specialists describing skin grafts on a 5-year-old, economists explaining what 70 surgeries does to a family, and then the jury saw the memo, GM letterhead, Edward Ivey's name, the math that valued a child's fingers at less than the price of a fast food meal. On July 9, 1999, the jury returned its verdict. $107 million in compensatory damages for medical bills, for pain and suffering, for the lifetime of care those children would need. And then $4.8 billion in punitive damages. $4.8 billion, not compensation, punishment, a message. The jury looked at GM's annual revenue, $3 billion at the time, and said, "You want to put a price on human life? Fine, here is our price." Total verdict, $4.9 billion, the largest personal injury award in United States history. But remember the open loop. The number they were awarded was not the number they kept. In August 1999, Judge Williams reduced punitive damages from $4.8 billion to $1.09 billion. He called GM's conduct clear and compelling evidence that they maximized profits to the disregard of public safety. But constitutional limits on punitive awards forced his hand. The final number, confidential, settlement before appeals ended, but here is what we know. When GM filed for bankruptcy in 2009, outstanding claims were reorganized at 12 cents on the dollar, 12 cents on the dollar, for a lifetime of burns and 70 surgeries. Did GM learn? Sort of. The verdict triggered a wave of lawsuits for the same fuel tank design. NHTSA strengthened fuel system integrity standards. Rear impact crash testing became more rigorous, but the real legacy is legal. Before Anderson versus GM, product liability cases were about proving a defect existed. After Anderson, they became about proving the company knew. Internal memos, cost-benefit analyses, the smoking gun behind the engineering. Today, when you hear about a massive verdict against a pharma company or auto manufacturer, the playbook is the same. Find the memo. Find the email where someone said, "We know it is dangerous, but fixing it costs too much." GM knew about the fuel tank problem in 1973. They sold the Malibu anyway, and kept selling that design for years. How many other memos are in filing cabinets right now? How many companies have done the same math, human life versus per unit cost, and chosen the cheaper option? That is not paranoia. That is what this case proved. Fast forward to today. In 2026, personal injury law looks different, but the core lesson of Anderson versus GM is more relevant than ever. When the Supreme Court decided State Farm versus Campbell in 2003, they established a presumptive single-digit ratio for punitive damages. Meaning, if you get $1 million in compensatory damages, you probably cannot get more than $9 million in punitive damages. Under that rule, Anderson's $107 million compensatory award would cap punitive damages at roughly $963 million, close to what Judge Williams reduced it to. But the jury's original $4.8 billion, almost certainly unconstitutional today. So why does this case still matter? Because it proved juries will punish corporations when evidence is clear. It showed plaintiff lawyers exactly where to look, the internal documents, and it made every company in America think twice before writing down that they chose profit over safety. Alicia Parker is in her 30s now. She has lived with those burns for over 3 decades. The money cannot undo Christmas Eve 1993. But the verdict she helped win changed the law for everyone after her. That is what one jury in Los Angeles did. They looked at a memo, looked at a child with no fingers, and said, "Enough." If this story made you angry, good. It should. The law is about holding power accountable, and sometimes one case changes everything. Drop a comment. Was $4.9 billion too much, not enough, or exactly right? I read every single one. If you want more legal breakdowns that actually matter, cases that change the system, hit subscribe. We drop 2 videos a week. Court case breakdowns on Mondays. Legal explainers on Wednesdays.